Hello, everyone. We're going to give folks a few moments just to get logged into the webinar today. So we'll just start at about 12:02 Eastern time, just to give folks a few more minutes to get in the webinar. In the meantime, feel free to drop your organization, your city and state in our chat box. See, we have a bunch of returning folks, but I also see some new names in the chat. Since we only have an hour, we're going to go ahead and get started. I just want to thank everyone for joining us today for another informative and interesting webinar. We have, over the past couple of months, hosted quite a few, and we've gotten spectacular reviews. So this training will be same of that interesting factor as well. So I want to welcome everyone to this webinar, and just to go over a few housekeeping items before we move into our presentation today. The chat box can be used to send messages to the entire group, myself, or our IT coordinator if you're having any issues. We do ask that if folks have any questions for our presenter, that you do add them into our Q&A box and not in the chat box. As you can see, folks are dropping their states and their organizations, so a lot of the time some of your questions may be overlooked if you do not put that in the Q&A box. So just make sure you are doing that, and at the end of the presentation, I will moderate that into our Q&A session. If any questions that we don't have time to go into today, we will be following up with another email, trying to kind of highlighting some of those questions, as well as our PowerPoint presentation and a recording of the webinar. And so, since we again only have about an hour, we're going to go ahead and get into this presentation. So let's introduce Mallory Allen.
Hi everyone. Very, very excited to be here, and honored to be able to speak to this esteemed group. So I will, I'll just briefly say kind of, who the heck are you? So my name is Mallory Allen. I'm an attorney. I'm based in Seattle, Washington. I'm a partner at the law firm of Fow Cochran Vertitas Amela, and our firm specializes in representing survivors of child sexual abuse. Originally in Washington State, but as time has gone on, we have more of a national practice now. So represent survivors in California, New Jersey, we've represented people in Guam, Hawaii, all over the United States. So my presentation today will be specifically about a case that recently came down from the appellate division in New York, under a Child Victims Act case against the Diocese of Albany. So, so everyone knows I will do my absolute best to make this presentation applicable and helpful for everyone, because I know we have such a wide range of skill sets here today. So we'll try to not make my presentation just catered to attorneys. So let me preemptively apologize to the non-lawyers if I get too much into the legal weeds here. But then likewise, apologies to any lawyers who are here if you feel like I'm stating the obvious. So bear with me here as I try to strike that balance. Let me start with just a little bit of general background. So New York passed the Child Victims Act, which in 2019 provided for a 1 year, which later became a 2 year window due to COVID, but originally a 1 year window where adult survivors of child sexual abuse were able to bring claims. Now, this was the first time in New York history that survivors were able to do so because the statute of limitations on claims like these had previously been extremely short. So someone who was abused as a child had until the age of 21 to bring a lawsuit. So as those of you who work with survivors, everyone on this webinar today knows, that's almost unheard of, right? Of someone in their early 20s to come forward. And most of the evidence shows it's not until people's 40s and maybe even 50s that they are able to really come forward and understand what has happened to them. So practically speaking, these lawsuits just didn't exist in New York. And as far as kind of backdrop about bringing cases like these, so in order to bring a claim against an institution for negligence related to child sexual abuse, which is the bulk of what we do. We certainly do claims against the perpetrators, but for a whole host of reasons that I won't get into here necessarily, those claims can be very difficult and not often worthwhile. And as all of you know, oftentimes these are systemic issues, not a one-off bad guy, but a systemic issue in the institution such that their negligence is what permitted this abuse to occur. So what you have to prove in these cases is what they call notice evidence. You have to show that the institution, so a diocese, a school, a foster agency, whatever it may be, either knew or should have known that the perpetrator at issue was a danger to children. So that's what I mean when I say notice evidence. Obviously, that can take many, many different forms. And as I'm sure many of you experienced, maybe if you've worked with survivors who have a lawsuit going on, I find that clients often think that the most important thing in their case is proving that the abuse occurred, right? Understandably, that's what they're more fixated on, right? Will people believe me that I was abused? And I often have to tell clients, that is really not where the battles lie. When it really comes down to it, the defendants, these institutional defendants, unless they can really prove or undercut that the abuse occurred, maybe the priest wasn't even assigned to the parish during the years you're alleging abuse, something like that. Anything short of that, they're going to leave that alone. They don't want to touch that with a 10-foot pole. But where they will fight really hard is that, hey, look, let's assume this happened. Let's assume you suffered greatly because of it, but we didn't know about it and we had no reason to know about it. And we're not negligent. We're not negligent. This was a bad actor doing something horrific, but we're not on the hook. So there's sort of two ways to prove, well, let's say three ways to prove notice. The first being kind of the most obvious and, what you'd ideally like to see in a case. And maybe let me just time out there really briefly. I often struggle, and I think all of us who represent survivors in lawsuits struggle with how to appropriately talk about good evidence in a case, right? Because good evidence means really horrific things happened. So please preemptively take my apology to the extent I'm saying this is really good evidence or this is good for the case, because I fully recognize that what that means is there's something really, really horrible that happened here. So back to what I was describing. So kind of that direct notice evidence is what you're always looking for, right? But in reality, those are really few and far between. That's the example where, you've got a client who was abused in 1970, and you find a document in 1968 that says a mom complained that her son was abused in 1968, right? So 2 years before your client's abuse, the institution did nothing. That is clear cut notice evidence. That's your kind of proverbial smoking gun, right? But that's just not the norm. Most of the time, you're going to have to prove your case based off of what we usually call constructive notice. So that's sort of a compilation of kind of red flag evidence, right? And let me share my screen and start my PowerPoint presentation for you here. And I'm going to leave it in this mode. If I put it in presenter mode, I can't see my notes at all. So forgive me that it looks like this, but I think we'll still get the point across. So constructive notice, right? These are kind of your red flags, or your, oftentimes you see this as kind of veiled language in complaints. And now this is what we see the vast majority of the time. And I put here just, these are actual quotes from cases that I have worked on. And so you see that, nothing here on this list, a questionable personal lifestyle, right? Personal issues, harmful to the public reputation, issues with chastity, immaturity, spending too much time with boys, affectionate, inappropriate, just fooling around, those kind of things. Nothing here explicitly references child abuse, but we would argue, and we do argue in our cases, that any documents or complaints, testimony that involves anything along these lines, if you hear from someone along this vein, you need to investigate further. All of these things could point to child sexual abuse. And something I'll talk about a little later in the presentation, this is particularly true if you're an institution that has a history of child sexual abuse, right? An institution that knows they have a major problem on their hands, something like the Catholic Church. Now, of course, conversely, if you've got an institution who's never had any issues, doesn't have the knowledge, maybe these things aren't evidence of notice, right? Constructive notice. So a third way, I would say, to prove negligence in these cases is to show that the defendant institution had supervision, or people say this different ways, supervision or control, care, custody, or control, or sometimes you'll see the phrase in loco parentis, which is just a Latin term for standing in the shoes of the parents. So a child who is under the control and care of an institution, that institution has an obligation to protect that child against any foreseeable harms. So, and the way that's a little different than constructive notice is maybe there is no warnings about the perpetrator at issue. That doesn't absolve the institution of an obligation to see where there may be policy issues or inherent dangers that may result in children being sexually abused. Even if they don't know anything about the perpetrator who abused the child before it happens, they can still be held negligent if they had improper policies, procedures, supervision, that kind of thing. So with that kind of background of the different ways we prove our case against an institutional defendant, I wanted to spend just a brief amount of time talking about how these cases are usually defended. And all this is, I think, important backdrop to talk about the Harmon decision. So what we often hear from defendants, and have seen this time and time again, it's kind of the playbook, is we didn't know any better. Okay. And this is the best defense in cases where they've been filed, like the CVA, under a revival statute, right? So where, it might be 2022, but the abuse at issue happened in the 50s, the 60s, the 70s, many years ago. And so what you'll hear the defense say, and what they'll try to kind of craft the testimony, will be, look, if we saw this kind of thing today, right? If we saw these red flags, or if we didn't have policies, that kind of thing, if this was today, we would have known better, and we would have never allowed this to happen. We would have nipped that right in the bud. But in 1965, we just didn't know about pedophilia. We didn't know about the harm that it causes to children. We didn't know that offenders couldn't just be cured with some counseling sessions. So you can't find us negligent, right? This is what the institution will say. You can't find us negligent because we did the same thing that the general public was doing. So we did not act inappropriately. And the reality is this defense can really work, right? So this is something that we're constantly fighting against, because as many of the really good research and good knowledge about both the prevalence of pedophilia, the fact that it's really not something that's curable, that it is something that perpetrators almost always repeat abuse. That didn't really come into being until later, when the research really was fleshed out. So the question becomes, as someone representing a survivor who was abused in the 50s, 60s, 70s, how do you address this defense? And the best way to do it, and that's why we sought the evidence we did in the Harmon case, which I'll talk about, is to prove that this institution had far better knowledge than the general public. Okay, they are not in the same shoes as the general public. And I think, among the best examples is the Catholic Church. They knew they had a massive problem on their hands way back in the 50s, 60s, et cetera. They knew how frequently abuse was occurring. And to that end, you need evidence to show what their knowledge was, right? So they can't get away with that defense of saying, "Oh shucks, we didn't know better." So with that in mind, let me just tell you very, very briefly about the Harmon case. So this is Michael Harmon is a survivor we represent. He was sexually abused for 5 years by Father Edward Pratt, who was the chaplain at at a place called St. Catherine's Center for Children, where Michael lived as a child. He came from a fairly troubled home, a single mom who had a hard time caring for him. And then after he left St. Catherine's, he then continued to be sexually abused, actually at the chancery. So the chancery being where the bishop lives, and Father Pratt at that point had been promoted to vice chancellor, which is sort of the bishop's second-hand man, secretary, that kind of thing, plans his calendars, manages his day-to-day activities. So in our case, we filed the complaint, and the diocese answered, and they had 21 affirmative defenses. So affirmative defenses are where the diocese says, not only do we deny all your allegations, but we affirmatively are going to make the following defenses, and this is why we are not liable in this case. Now, one of these 20 plus affirmative defenses was exactly what I just talked about, right out of the playbook. They say the church defendants' actions were in conformity with professional best practices and with the available knowledge in the community and met applicable standards at the time, right? So wordy, but what they're saying is we didn't know any better at the time, right? Exactly what we just talked about. Given that defense, we then requested in discovery, right? So you can request documents in the discovery phase. We requested a handful of documents, various categories of documents that we thought would allow us to undercut that defense, to disprove that defense. So among those was sexual deviancy treatment records. Many of you may know about these sexual deviancy treatment centers that the Catholic Church sent offenders to for many years. There were quite a few. Usually the one that's most kind of infamous is the Servants of the Paraclete in New Mexico, so you may have heard of that. There's also a place called St. Luke's. The institute that's at issue in this case is called Southdown. So there were a few of these nationwide that they sent offending priests to, and then sadly, often, they'd do a couple week or couple month program, and then they put them back into ministry where they would then reoffend. Often they would put them back into ministry even where the providers at these institutes said that they had fears that these priests would reoffend. So we requested all of these records. And the only reason we knew that they existed was because in Father Pratt's personnel file, there were these two letters. And I won't read them to you, but you'll see that clearly the bishop in Albany was corresponding with the provider here at Southdown Institute, thanking them for sharing the treatment plan, the analysis of Father Pratt's condition, and that kind of thing, and pretty obvious that the bishop was intimately involved in the treatment. So we requested all of these records. Next, we requested the personnel files, or the secret files. You often hear them called different names. And again, if you followed, much of the clergy sexual abuse scandal, you may have read that this was very common, that the diocese nationwide would sort of have a normal personnel file, and then they'd keep a secret file regarding priests who had sexually abused children, and they would keep that separate and apart from the normal file. So we sought production of all of those files, including every single priest who was on what's called the credibly accused list. And again, this is something that several dioceses have done nationwide, namely that they have created lists, right? Publicly released lists of priests who they determined internally, and they have not, as far as I know, no diocese have kind of revealed to the public what their measuring stick is, but have added priests to this list who they have concluded are credibly accused. Often that means there's more than one allegation against them, and the diocese has done some sort of investigation that they've determined, yes, this really did occur. And so here, what I've got here on the slide is the list from Albany. So you'll see very minimal information, just names, when they were added to the list, when they were ordained, and when they were removed. So very minimal information. Of course, they kept all the secret files, right? The files that talk about what these perpetrators actually did and when they did it, they had kept those secret while releasing these lists. So we asked for every file of a priest on that list, knowing full well that this is a list of who they admit abused children. So I think anyone who's done any work in this field knows that a list like that is going to be wildly under-inclusive, right? I mean, it is likely to leave out dozens of perpetrators of abuse. And frankly, this list of 60, I would not be surprised if it's double, or who knows, even triple this, who use their position with the diocese to sexually abuse children. Because of course, this list also doesn't contain lay people who may have used their positions as teachers, administrators, janitors, to abuse children within the diocese. So the next category of documents we requested were the what are called the Independent Mediation and Assistance Program files. So the diocese called this IMAP. And this was a program that went into effect in the early 2000s and only lasted about 2 years. it was about 2004, I believe, when they opened this program, and it was kind of a very rushed program where people had to make claims within a certain, I think it was like 120-day period. And it was put in place before survivors in New York had actual legal redress, right? So in a lot of ways, this program, yes, it compensated survivors, but it was very much a take it or leave it approach. In my opinion, they offered just pennies on the dollar to survivors. But what was your alternative at that juncture, right? You had no ability to file a lawsuit, so you had no leverage. Now, of course, when they provided these settlements to survivors, and based on news reports, they settled about 50 claims through this IMAP program between 2004 and 2006. They made survivors sign a release that released any ability to bring a lawsuit in the future, even if New York changed their laws. So sadly, all those people, who I think, like I said, were wildly undercompensated, have no ability to bring a claim under the CVA. So we requested those files as well, both on Father Pratt, right? Other survivors who had made claims that Father Pratt had abused them, and then also on the list of clergy who were on the credibly accused list, essentially arguing, hey, these IMAP files are kind of part and parcel of the secret file, the personnel file, that kind of thing. As I'm sure you can guess, the diocese objected to producing all of these documents, claiming they were either irrelevant, prejudicial, protected by some sort of privilege. So this required that we filed a motion to compel the diocese to produce them. So we argued that motion in the Albany Supreme Court, and as far as the sexual deviancy treatment file, so I'll just kind of briefly run through some of the arguments that were made and how the court came out on it. So the diocese argued that, yes, they had required Father Pratt to undergo an evaluation at South Down Institute, right? One of these institutions where they treated clergy sexual abusers. And they said, however, look, the relationship is between the diocese and the physician and the priest, and that those communications between the three of us, essentially, are privileged. Yes, the priest consents to the bishop reviewing the files and intimately participating in the treatment, but that doesn't waive any privilege. And I think, as most of you probably know, there's privileges, right? Attorney-client privilege, physician-patient privilege, and those are protected by law. You don't have to disclose those communications unless you waive it. And what waiver usually means is sharing it with a third party. So technically speaking, if I tell client my advice and I put that in an email, and then they forward it to their brother-in-law for advice about whether I know what I'm talking about, they have just waived the attorney-client privilege on that communication because it has now been shared with a third party. So that was our argument, right? You don't get to have a three-way privilege. That's not the way it works. The privilege, if it existed at all, is between the physician and the patient. Of course, presuming these priests were even being treated by physicians, because as many of you may know, oftentimes they were just other priests who were treating them, so they weren't even licensed physicians. But putting that aside, assuming he was treated by a physician, he waived that privilege when he told the bishop that he could be intimately involved in the treatment, and that the bishop could make his decision about whether Father Pratt returned to ministry based on that treatment. We argued, look, there were no efforts to maintain confidentiality, and clearly there was no expectation of privacy here. So this was waived. And the court agreed. So the trial court agreed. And as you'll see here, this is a quote from the trial court's opinion. And he says, Father Pratt waived any privilege by consenting to its release to the bishop for use and consideration in deciding whether Father Pratt was fit to resume his ministry. And then he says, accordingly, the documents in Father Pratt's file that have been withheld under a claim of physician-patient privilege must be disclosed. So the next issue that we argued to the court was the production of the credibly accused priest files, right? These secret files of the 60, at the time it was only 48. So in the time that I argued this to the court it was actually in late 2020 that it was first argued to the court. Between now, quite a few additional priests have been added to the list. So the diocese said, we do not get these files. The unrelated priest files are irrelevant to the plaintiff's claims, extremely prejudicial for them to have to disclose this stuff. They also argued it would be burdensome for them to have to disclose it all, collect all 60 files, review them, that kind of thing. They claimed it would violate privacy rights of the perpetrators, which is rich. But they also argued that it would violate the privacy rights of survivors as well, and that it would result in the disclosure of privileged information. And that the real crux of the diocese argument as to why they believe that they did not have to produce these priest files was that they asserted we had only one ability to prove our claims, right? So earlier I talked about, hey, look, there's 3 avenues here to prove sexual abuse, to prove notice evidence that they're on the hook for negligence. They argued that the only avenue under New York law was to show particularized notice of that perpetrator's propensity to abuse children. So they said the only way you can prove your case is if you can show that the diocese knew before Mr. Harmon was abused that Father Pratt was a danger to children. And they argued that is the law in New York. Now, of course, I think it kind of goes without saying, and that's in part why we're having this webinar today. There was a lot of case law kind of nibbling around the edges on these issues, but nothing directly on point, obviously because New York was such a prohibitive state to bring claims like these. So most everything that was brought before the court was what we call an issue of first impression. So this was the diocese argument. Under New York law, only one avenue, and the other priest files are just simply not relevant to show what the diocese knew about Father Pratt. Only Father Pratt's files are relevant on that issue. So we argued that the files were relevant under 4 different bases. So first, that they rebutted their affirmative defenses, right? Which we talked about earlier, namely this defense that their actions were in conformity with professional best practices and available knowledge in the community, right? If we could show that their knowledge was superior, that they knew at the time of Michael Harmon's abuse that there was an unbelievable level of child sexual abuse going on in the diocese, kind of the smoke and the red flag evidence we had would be enough to prove their negligence. Second, we said, look, it will show that they had knowledge and that the danger, the foreseeability of sexual abuse was there, right? Again, when plaintiff was in their care, custody, and control, right? When they had care over him and were responsible for him, they should have instituted policies, procedures, watched closely to ensure he wasn't sexually abused, regardless of what they knew about Father Pratt. And then 3, we said, look, this gives context, even on plaintiff's other claim, right? This claim that they knew or should have known about the abuse, it gives context to those claims. Relatedly, how they should have behaved and what should have been alarming to them depends on what they knew. And then lastly, we argued, look, this is also relevant if you need to apportion fault between defendants. So that's what happens in a jury trial, right? You may have multiple different defendants. So in our case, we had the diocese and we had St. Catherine's Center for Children. The jury would need to determine who was culpable and to what percent. So you may have a jury say, hey, the diocese had all this information about child sexual abuse. They are 70% at fault, and St. Catherine's is 30%. Well, how does the jury do that without knowing each defendant's knowledge? So interestingly, so at oral argument on the motion, so when myself and the lawyer for the diocese argued these issues to the court, the diocese actually admitted that they intended to call 2 expert witnesses on the issue of their affirmative defense, that they behaved appropriately given the community standards at the time, right? So that this was handled customarily as the general public would have handled it. And here's a quote from the transcript from the oral argument. And this is, as you can see, the court, and then Mr. Costello is the attorney for the diocese. But the court essentially asking him the question of, wait a minute, you're going to have an expert come in, and he's going to testify that the diocese acted appropriately given their knowledge at the time. Mr. Costello says that's a fair assumption. And the court says, and you don't think it's fair that the plaintiff should be allowed to cross-examine that expert regarding what happened concerning other cases of abuse predating this, specifically in this diocese, to challenge that opinion, right? So what was their available knowledge at the time? And, backed into a corner, what else is he going to say? And the attorney for the diocese says, well, that would be a way to challenge the expert, and the expert would have to address that. He then goes on to say, but it's still not relevant for the following reasons. But I think after that admission that it's like, well, but of course the plaintiff gets to challenge your assertion. If you're saying you behaved reasonably given your knowledge, you can't then withhold your knowledge. So I think in large part based on that, the court, this is a quote from the court's opinion, and he says, to allow the defendants to base their defense on what they knew about clergy sexual abuse problem, but at the same time withhold that information from plaintiff would be fundamentally unfair and highly prejudicial to plaintiff, right? So it's just it's not a highly sophisticated legal concept, right? It's like, wait a minute, that's not fair. Is essentially what the court held, and what we argued, right? That without these files, we would be at an enormous disadvantage to challenge the defense and challenge these experts. And if they wanted to go forward with this as their defense, then they needed to cough up the documents that were relevant to it. The court likewise held, though, so he didn't just rest his opinion on that notion alone. He also held that entities, he recognized entities have a duty, entities just like the Diocese of Albany, have a duty to protect children under their supervision and in their care, custody, and control, and that an entity can be held negligent if they fail to protect these children against foreseeable harms. In a lot of ways, I think to all of us on this call, that seems so painfully obvious. But there wasn't really a case in New York that was directly on point on this issue. A lot of school cases that talk about this, but really nothing outside of the school context, which frankly I was shocked by when I started, really diving into the case law and what other New York courts have held. So again, one of the reasons why this is such an important opinion, because this issue just has to be solidified in the case law. And one of the ways I think we really drove this home for the court is we explained, look, let's use a hypothetical, okay? It cannot be true that the diocese can only be held responsible if they have direct notice of a perpetrator, but can't be held liable for foreseeable harms. And the example that I used was, okay, let's say a boarding school leaves their doors open every single night, doesn't lock their doors, and that there is no adult supervision at the boarding school. Doors are open, kids just roam free. Now, if the diocese were right that foreseeable harm wasn't a cognizable claim, right? A way to prove negligence, then this boarding school would never be held liable, regardless of whether, let's say on a nightly basis, a perpetrator came in and physically or sexually assaulted these children. Because the boarding school would just argue, well, we didn't know John Doe. We didn't know he had a propensity for sexual abuse. And that's the only way we can be held liable under New York law. I think the hypothetical shows that the absurdity of the argument. Now, of course, this boarding school could be held liable because it's negligent to leave your doors open. It is foreseeable that if you leave your doors open, somebody may come in and assault the children that are in your care. So I think this really resonated with the court, that look, that this is not the law, and it definitely cannot be the law in New York, and that this is kind of a dangerous precedent to set if you say that this is not a cognizable way to prove negligence. And then another reason why the court held these documents should be produced is exactly what we were talking about before, which is it's hard to judge an entity's conduct in a vacuum, right? Whether their conduct was reasonable, given what was going on, depends on whether they knew better, right? Depends on what the history was. What we expect to see, right, is, well, let me give an example of the actual case, right? So the Harmon case. So as I mentioned before, Father Pratt regularly had Mr. Harmon stay the night at the Chancery, right? Now, this is where Bishop Hubbard lived. Hubbard himself testified that he knew that this was occurring, that children would stay the night from time to time at the Chancery, but he thought nothing of it. Now, if the evidence shows that dozens of priests had abused children who they had stay the night at the rectory or the Chancery, I would argue that a jury could easily conclude that Bishop Hubbard's position, right, that this was no big deal, was unreasonable and it was negligent, and that this is evidence of notice and plaintiff wins his case accordingly. Likewise, if no one had ever sexually abused a child in either the rectory or the Chancery, right, having a kid stay overnight, well, maybe they have a better argument that allowing Mike Harmon to do so wasn't negligent. But we need the evidence to put that in context. And another argument, of course, is let's say the evidence was the opposite, right? If Father Pratt was the first priest in the diocese to ever sexually abuse a child, you don't think the diocese would try to admit that evidence on the question of foreseeability and was their conduct reasonable? Well, of course it would, right? So the court considered that issue and cited to a Pennsylvania case that I think has a great quote. And that's clearly an individual or organization which has been exposed to and has some experience in dealing with a particular situation may be better able to recognize a subsequent similar situation. Again, right? I mean, it seems pretty common sense, but there really wasn't any New York law on this exact issue. So with all, for those separate bases, the court ordered production of all of these files, and he had two qualifications. He said all of the survivor names must be redacted, and only files which predate the last date of plaintiff's abuse are relevant, right? So just the stuff that would have shed light on what was reasonable up until the time of plaintiff's abuse. So the last issue before the court was the IMAP records, right? And essentially the court held here, look, the diocese has denied that Michael Harmon was abused. The production of files that show that others were abused by Father Pratt are relevant. It's what we all saw in the Me Too movement. Of course, it makes it more likely, right? It's easier for us to prove that Mike Harmon was sexually abused if you can show that Father Pratt abused 13 other children. It becomes much less likely that Mike is making this up. So we argued it was admissible for that reason. And then for this, the other IMAP files were admissible, like I said, just like the priest personnel files are. And the court agreed. And like I put here on this quote here is from the court in the blue at the bottom here. The defendants are within their rights to answer the complaint and deny the abuse occurred, essentially. But this has consequences. It frames the issues and determines the scope of discovery. In other words, if they want to deny that the abuse happened, then these documents become relevant. So predictably, I think, the diocese was very displeased with this order, right? Particularly, I think, because it was the first trial court order of its kind, and they were fearful that this was, going to be the rule across the board. So they appealed basically every aspect of the trial court's order to the Third Department Appellate Division, so the next court in line. And the appellate court, essentially held that Judge Mackey, so the trial court, was right at every single turn. I think in some ways they even held that the documents were admissible for even more bases. And really our theme that we argued to the appellate court when I went to Albany to argue this was, look, the diocese is trying to have this case both ways, right? They're taking the position, they had no notice of propensity, nothing was foreseeable here. How could they possibly have known that this was going to happen to Michael? But at the same time, withholding the documents that may disprove that very assertion, right? Or directly undercut that position. They can't hide behind the knowledge and standards of the community while then withholding what it knew and what its specific practices were. And that resonated with the court. And again, the court essentially held Mackey was right on all fronts. And we're running a little short on time, so I won't go through these in detail, but we will share the PowerPoint afterwards if anyone's interested. And of course, happy to share the appellate opinion, anything people would like to see after the presentation. But, I've pulled up kind of the important quotes, mainly just being that, look, this was a waiver, right? On the sexual deviancy files, this was a waiver. You don't get to share it with third parties. On the credibly accused files, it's not burdensome to produce them. They are plainly relevant for multiple different claims. And the diocese put these at issue when they claimed that they didn't know any better than the community. So let's see what they knew. And then the ruling on the IMAP was basically the same thing, right? They put these questions at issue, and the plaintiffs get to see, the survivors get to see what the documents actually show. So I think, as far as kind of what's the impact here, and I know in a lot of ways, probably some of you feel like you're drinking from a fire hose here as I rattle off our legal arguments. And so I kind of sat back and thought, okay, what kind of impact is this case likely to have on other cases in New York, statewide, but then frankly, in any case nationwide where there is an authority on these issues? Because I do believe that we will continue to see additional states opening revival windows, just like New York. And there's not a wealth of authority on these issues. There's a few cases in California, a few in Washington, states that had previously opened up windows or changed their statutes, but not a ton. So I think the most important takeaways from Harmon and the most impactful aspects of it are going to be, look, the affirmative defenses matter. They frame the scope of what is discoverable. So you don't get to deny claims. You don't get to say we behaved reasonably and then say, wait, plaintiffs don't get the evidence to undercut that. Sorry, too bad. If you want to assert those defenses, you open the door to discovery on those issues. If you want to admit the issues, maybe the plaintiff doesn't get discovery on it, but you don't get to have it both ways. And then second, kind of major impact here is the diocese doesn't get to keep these treatment records, right? These treatment records from these infamous sexual deviancy centers, privileged by claiming that they hold a privilege, right? That's a waiver. They are not a third party to that arrangement. And when the priest gives them access to the files, that is waived. There is no more privilege there, and that's huge because we know these priests were sent. Hundreds, if not thousands, of priests were sent to these centers nationwide, and those records should be public. They should be discoverable in these cases. And as far as another impact, and I think this is one that I think is probably a tough one, as I thought about doing this presentation today, a tough one for this group, and something that I think is probably a little more divisive, and would be curious to hear, others' thoughts about this from a purely victims advocate position, because, the court did rule that plaintiff is entitled to know the names of those others who were abused by the same perpetrator. So all the names on the credibly accused list, all those survivors, those will be redacted, right? Those, we don't have any business knowing those, and I don't need to know them at all. But the survivors who were abused by Father Pratt, I did argue that Mike has a right to those names, to prove that others were abused so that I can contact them as potential witnesses, hear what they have to say. Who knows, Pratt may have admitted to abusing Michael while he was abusing one of those kids. One of those kids may have complained and the diocese never wrote it down. I mean, there's sort of an infinite number of reasons that that testimony could be critical to Mr. Harmon's case. And that's my obligation as his lawyer, right? Is to track that down, find those witnesses, do everything I can to zealously advocate for him. But, I recognize that could be a very sensitive issue for survivors. I think the diocese is plainly wrong when they say they don't have an obligation to produce those names. I find it almost offensive that they think they get to be the gatekeepers of that information, paternalistic to say the least. But again, my argument is this kind of full disclosure is indispensable to the truth finding process, and that's the nature of civil litigation. And in a lot of ways, my experience, and again, that's why I said I'd love to hear what others think, because my experience and the firm's experience, having represented survivors for many, many, many years, is that most of the time when we reach out to potential witnesses, which we do in as most of a trauma-informed manner as we possibly can, they want to help. They want to band together, they want to speak out, they want to help someone like Michael. So that's our experience across the board. Now, of course, we've always had, we've had times where survivors have not wanted to participate, and we do our best to respect that. But again, this is an issue that I think is probably of interest to this group, and a tough one, I think. So another impact, which is what we talked about quite a bit here today, which is, of course, an entity has a duty to care for the children in their care, in their custody, and they have to protect them against foreseeable harms. Crazy that had to be delineated, excuse me, but it did. And now it's a part of New York legal authority, which is so important. And I think, like I said, there were some cases in the school context that recognize this, but the fact that there's now one in a diocesan context, I think makes it a lot easier to argue that this is the case across the board at different entities. Is there an obligation when someone's just a parishioner or an altar boy? I would argue absolutely yes. That you are holding yourself out as doing youth programming, and you need to protect those youth in your programs. So I kind of expect that to be the issues likely coming down the pike. And then the last two I would say is, just sort of practically speaking, because this is the first appellate opinion on these issues in New York, it can and should be used in cases statewide and frankly, nationwide to the extent the issues come up in other states. Until another appellate court in New York holds otherwise, which I sure hope they don't, this is the law of the land, right? It's the highest court has spoken, and this should be the authority in other trial courts, in New York City and in Brooklyn, in Syracuse, it shouldn't matter. And then likewise, a lot of what the diocese hounded on is it's so burdensome to get all these documents. How are we to get all these documents? They date back to the 30s and 40s. This is going to be an enormous effort. And both the trial court and the appellate court really shut that argument down, which I was very happy to see, because I think this is something that we are hearing across the board from these institutional defendants. And frankly, it's a little absurd, right? And it sort of undercuts the entire purpose of the Child Victims Act, which is to, the legislature, in other words, determined the CVA was necessary to right historic wrongs. Well, that's going to result in the need to go back and review historic documents. So defendants should not be arguing that this is too burdensome. I mean, sorry to be flip, but too bad. That's what the legislature wanted you to do. So we can right these horrific wrongs where people had no redress for decades. So it's nice to see some authority on this to cite to for those defendants. I also think it's an ironic argument, and I argued this to the trial court as well, which is, well, Your Honor, they can hardly argue this is burdensome because the files are so voluminous. Isn't that why they're relevant? Right? If there is thousands and thousands of pages, 60 credibly accused perpetrators, it's going to take me forever, Your Honor. It's like, well, that's all the more reason I'm entitled to them, because clearly there was a massive problem in the Diocese of Albany. That's why they're relevant. So that sort of wraps up. Let me stop sharing, because while I was sharing, I realized I can't say, okay, in the Q&A. So, I think kind of broadly speaking, the Harmon decision made clear that cases like Mike Harmon's don't need to be decided in a vacuum, which is always kind of the trick of the defense. Isolate a survivor, make them feel like they're alone, they're a one-off, that kind of thing, when we know that child sexual abuse is a systemic problem. And what has happened over the years and what the institutions know is extremely relevant. And frankly, just from a personal standpoint, I think this is so important for survivors to kind of see they aren't alone. While it's really upsetting to know the lack of policies in place, the blind eyes that were turned to obvious red flags and all that kind of thing, it also, I think, is of comfort to the survivors to know, hey, this really wasn't my fault, right? This was a massive failure of an institution, and I didn't do anything wrong. So for that reason alone, I think this is a huge win, for clergy cases, obviously, but really cases against any institutional defendant in New York and elsewhere. So a couple minutes early, if anyone has any questions.
Yeah, we'll open up the Q&A session. So if anyone has any questions for Mallory, feel free to input those in the Q&A box. We'll give folks a 30, 45 second breather for that.
And I'm also happy afterwards to answer any questions via email or, connect with anybody at all. So, or share briefing, that we've got, the opinions, anything that people are interested in, I'm happy to.
Yeah, so it doesn't look like we have any questions. So what we can do is, when we do follow up to all of our registrants with the recording and the PowerPoint presentation, we'll also add Mallory's contact information. So if anyone that joined us today or signed up and wasn't able to join us can follow up with any questions. But again, Mallory, thank you so much for sharing your experience and this information with our attendees today.
Of course, a pleasure to be here. So thank you so much for having me.
Okay, everyone have an amazing week, and we will probably see you soon.